Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross LLC. I'm a practicing business attorney with over 15 years of experience of helping entrepreneurs start and grow a business. Today we're going to talk about corporate governance. When most business owners hear the word corporate governance, they assume that it's only a large corporation problem that applies to large companies like Apple, Netflix, Nvidia, and companies like that. But that assumption is wrong and can be one of the most expensive and time-consuming problems for a business to fix. Corporations have rules that need to be followed by everyone who owns and operates a corporation. If you don't follow them, your corporation can be dissolved, or a creditor can seek to pierce the corporate veil and hold you personally liable for the debts and obligations of the business. And even if you're lucky enough for none of those to occur, you still need to comply with basic corporate governance rules in order to keep peace among your shareholders and eventually sell your business to someone else. So today, I'm going to walk you through 6 pillars of a robust corporate governance program for Massachusetts corporations. I'll explain each element, why it's needed, and how to implement it. Stick with me to the end, and you'll have a clear roadmap of how to make sure that your corporation is legally airtight so as to minimize shareholder disputes and maximize the protection for your other personal assets. So let's get to it. The first pillar for your corporate governance program is to have customized articles of organization for your corporation. Your articles of organization are the foundational charter document for your corporation that you filed with the Massachusetts Division of Corporations. It contains 8 articles, some of which have to be completed while others can be left blank. I posted an earlier video discussing how to complete articles of organization for a corporation, and I'll post a link to the video below. In your first article, you have to identify the exact name of your corporation, and this absolutely has to be completed. Otherwise, your corporation won't have a name and it will be rejected by the Massachusetts Division of Corporations. So, for example, if you want to call your consulting company Sunshine Consulting Corp., you would need to put that information in Article 1. In your second article, you need to identify whether your corporation has a limited purpose. By default, in Massachusetts, every corporation formed under MGL Chapter 156D, which is the Business Corporation Statute, have the purpose of engaging in any lawful business in Massachusetts. So there's really no need to put anything in Article 2 unless you want to restrict the purpose of your corporation. And it's really not clear why you'd ever want to do that. In the third article, you need to identify how many shares of stock the corporation is authorized to issue. The base cost for forming a corporation in Massachusetts is $265, which allows you to authorize up to 275,000 shares. Whenever I set up a corporation for my clients, I strongly recommend that they authorize the full 275,000 shares. They don't need to issue all of them right now, but it creates a bank of shares that can be used in the future to reward employees or if you need to take on outside investors. One common mistake I see here is that sometimes business owners who set up a corporation by themselves only authorize a small number of shares, such as 100 shares. They then split these shares equally with the other owners because they think that that's all they need. This is a big mistake and confuses the difference between authorized and issued shares. Issued shares are the shares that are actually owned by shareholders in exchange for some type of consideration, such as cash or services. When the shares have been issued, the owners are entitled to receive a share of the profits and losses of the corporation and often have voting rights. It makes complete sense to only issue 100 shares when you only have a few shareholders and split them equally among the owners. But authorized shares are completely different and are simply the total number of shares that the corporation has available to issue to shareholders at any time. Authorized but unissued shares don't receive a share of the profits and do not factor into quorum or voting requirements for the corporation. And 100 is too few because you never know what you might need shares for in the future. And since you get up to 275,000 shares with the filing fee, you might as well take them and save them for future use. Now, if you want to authorize more than 275,000 shares, you can certainly do that, but it will cost you additional filing fees, usually $100 for every 100,000 additional authorized shares for the corporation. Speak with an attorney if you're not sure how many shares to authorize or issue in connection with forming your corporation. In the fourth article, you need to identify whether your corporation has different classes of shares or just a single class of shares. Most people who set up their own corporation themselves leave this article blank, which means that your corporation only has a single class of shares. However, this is where you really want to start thinking about corporate governance matters and whether you want to have different classes of shares. Often, many corporations want to have multiple classes of shares to create different rights amongst their shareholders. For example, many corporations want to have one class of shares which has voting rights and another class of shares which doesn't have voting rights. That way, you guarantee that only certain shareholders have a say in who the directors of the corporation are and are otherwise involved in running the corporation. Another common reason to have multiple classes of shares is if you want to create a class of preferred stock in your corporation that entitles certain shareholders to get a larger portion of any profits or distributions. Keep in mind, though, that if you're an S corporation, you can't have a second class of shares with different distribution rights. If you do that, you'll be violating S corporation requirements and you'll be disqualified from being an S corporation. Either way, however, if you want to have multiple classes of shares in your corporation, it needs to be identified in Article 4 of the Articles of Organization. Otherwise, you can't have multiple classes of shares and you can only have one class of shares in your corporation. In the fifth article, you need to identify whether there are any restrictions on the transfer of shares of stock in the corporation. Most individuals who set up the corporation themselves or use something like LegalZoom leave Article 5 blank. This can be a big mistake, as there are often good reasons to put restrictions on the transfer of shares. For example, if you have a family-run corporation with only family members as shareholders, you may want to make sure that the shares can't be transferred to any other random third party without the approval of the other shareholders in the corporation. One way to do this is to put these restrictions in Article 5 of the Articles of Organization. You can also put the restrictions in the bylaws or shareholder agreement, both of which I'll talk about in a minute. But the simplest and most public way to do this is by putting the restrictions in Article 5 of the Articles of Organization, and that way you don't need to include them in other documents. Otherwise, if you don't put the restrictions anywhere, you run the risk that shareholders can sell their shares to anybody, even if you don't want to be in business with that other person. In the sixth article, you need to identify whether there are any other lawful provisions to include as part of the Articles of Organization. Most people who form their own corporation without the help of an attorney or use LegalZoom or similar services to form the corporation leave this article blank. However, under MGL Chapter 156D, the Massachusetts Business Corporation Statute, there are certain important corporation governance provisions that you want to consider adding in this article. I'll discuss two important ones here. First, Article 6 needs to authorize shareholders to act by written consent without a meeting, even if there is less than unanimous written consent. Being able to act by written consent is one of the easiest ways to minimize the difficulties of complying with all the corporation rules and requirements that need to be followed. However, the default rules of the Massachusetts Corporation Statute is that the shareholders can only act by written consent without unanimous consent if the Articles of Organization allow it. Otherwise, you need to hold an actual meeting, which can be a real pain. So, you want to make sure that Article 6 of your Articles of Organization authorize action by written consent of the shareholders, even without unanimous consent. Second, Article 6 should also address the number of directors that you are required to have for your corporation's board of directors. Under the Massachusetts Corporation Statute, the default rule is that you must have at least members of the board of directors if you have more than one shareholder, although you can have two members of the board of directors if you have two shareholders. This default rule can be overridden if there's a specific provision in Article 6 of the Articles of Organization that says you can have less than 3 directors of the corporation, no matter how many shareholders you have. Let's move on to the 8th article, which is not a permanent part of your Articles of Organization. In the 8th article, you'll need to identify the initial officers and directors of the corporation, as well as their principal place of business, the registered agent, and various other things. All these are, of course, important to how your corporation is run, but they are not a permanent part of your articles and can be changed each and every year when you file your corporation's annual report. Now, a lot of you might be thinking that you already have a corporation, but your Articles of Organization don't contain any of these specialized provisions. Don't worry. These can be easily fixed by amending your Articles of Organization. However, the process for properly amending your Articles of Organization can be fairly detailed depending on what your current bylaws and Articles of Organization already say. So, I recommend that you speak with an attorney for assistance to make sure that any amendment to your Articles of Organization is done properly. The second pillar for your corporate governance program is your corporate bylaws. The Massachusetts Business Corporation Statute requires every corporation to adopt bylaws, and if a corporation doesn't apply bylaws, it hasn't been properly set up. Think of the bylaws as the operating manual for your corporation, and Massachusetts law treats a corporation's bylaws as a contract among the shareholders of the corporation. A corporation's bylaws can contain any provision that's not inconsistent with Massachusetts laws or the Articles of Organization. Ordinarily, they should define and contain, at a minimum, the information that's displayed on your screen. Speak with an attorney if you need some help. Aside from not having bylaws, the biggest mistake many Massachusetts business owners make is downloading a generic set of bylaws from the internet or having ChatGPT create them. Here's why that's a problem. Massachusetts has very specific default rules in the business corporation statute, some of which are not that favorable. If your bylaws are silent on these issues, or if they use generic language from another state like Delaware or Nevada, the business might inadvertently trigger the default rules under the Massachusetts corporation statute, which may not be all that desirable. Here are some of the key default provisions that need to be customized and addressed in your bylaws. First, your bylaws should address quorum requirements about what percentage of shareholders and directors need to be present at a meeting to make the vote valid and binding on the corporation. Under the Massachusetts Business Corporation Statute, the default is that a majority of the shareholders or directors must be present, but the bylaws can increase or decrease that number to no less than 1/3. And for certain types of decisions, such as deciding to close the corporation, merge with another company, or pay dividends to shareholders, it is often good practice for the bylaws to require a supermajority quorum and vote of the directors and shareholders for these decisions. A supermajority is usually at least 75%, although it can also be unanimous. Second, your bylaws should also address what officers the corporation will have and what their duties are. In Massachusetts, a corporation must have a president, a treasurer, and a secretary. The bylaws need to clearly define what their specific authorities are, especially when it comes to signing contracts or binding the company financially. And if you want your corporation to have other officers, these positions need to be spelled out in the bylaws and what the individual's duties and responsibilities are. Third, your bylaws should identify the conditions under which directors can be removed and whether a director can be removed without cause. This can be a delicate matter, so you want to make sure and speak with the other shareholders about when directors can be removed. Remember that directors are appointed by shareholders and can usually be removed by shareholders under certain conditions. These conditions, including any voting requirements, should be explicitly spelled out in the bylaws. Otherwise, the default rules apply, which is that, generally speaking, a simple majority of directors or shareholders can vote to remove a director. There are lots of other provisions that should be included in your corporate bylaws, and you want to make sure that they reflect how you actually want the business to be run. Speak with a knowledgeable business attorney if you have any questions. And remember, bylaws should not be treated as a file and forget document. Review them regularly, and definitely anytime your ownership structure changes, or when you add or remove an officer, or when you bring on an outside investor. The bylaws need to reflect how your corporation actually operates, not how it should be operated or how it operated on the day you formed it. Bylaws are binding on the corporation, and any officer or director who is operating in accordance with the bylaws is presumed to be operating in good faith. The third important pillar of your corporate governance program is a strict commitment to keeping appropriate director and shareholder minutes and maintaining a minute book, either in electronic or physical form. Under the Massachusetts Corporation Statute, every corporation must keep minutes and records of all shareholder and director meetings for at least the past 3 years. These minutes must be kept at an office in Massachusetts, which can be the corporation's principal office, the office of its registered agent, or some other appropriate office. A few things to note here. First, these minutes do not have to be only of meetings that are held in person. Remote meetings are fine so long as they are not prohibited by the bylaws or the Articles of Organization. Second, formal minutes should identify the date of the meeting, who was present, the matters that were voted on, and how everyone voted, and the minutes should be signed by the secretary. After the minutes are signed, all minutes should then be stored in the corporation's minute book, which is an electronic or physical document. Third, you don't actually have to hold a meeting, and written consents that are consenting to certain actions are fine. As I discussed previously, so long as specifically permitted by the bylaws and the Articles of Organization, in lieu of a meeting, the directors and shareholders can sign a consent that indicates that actions that were taken and their approval of the actions. The consents should contain all the same information as minutes except that they will not have a meeting date, but should have an effective date. These minutes and consents are extremely important for any corporation. Case law has shown that these records are presumed to correctly reflect all actions shown in them as taken by the shareholders and directors, unless there is material evidence that they are incorrect. So make sure to keep accurate minutes and consents for any major decision that the shareholders and directors vote on and store them in your corporation's minute book. Now, an obvious question you might have is, what types of actions need to be recorded in these minutes? And that's a great question. And there's really two basic categories of actions that should be recorded in minutes or written consents. The first category of actions are those actions that need to be taken each and every year. Every single year, a Massachusetts corporation is required to hold an annual meeting of the shareholder in which they elect the directors, and an annual meeting of the directors in which the directors appoint the officers. Even if the business is a single shareholder corporation where one person is the sole shareholder and director and holds all the officer titles, these meetings still must appear on paper. I know it seems ridiculous, and to some extent it is. But corporations have certain rules, and if you don't follow them, you're at risk because of a legal concept known as piercing the corporate veil. If a corporation is ever sued, and there is some evidence that the corporation has not been following all the required rules, the opposing party may try to prove that the corporation is just an alter ego of the owner rather than a separate legal entity. So, if annual corporate meetings are not held, or if minutes are not kept, this is one factor that a court may consider in determining whether the corporation is a real entity. And if the court decides that the corporation is not a real entity, it can strip away the corporate shield and remove any limited liability protection you may have from the debts and liabilities of the corporation. This means that your other personal assets, such as your personal savings, your home, and other personal assets are at risk. The second category of minutes that should be kept are minutes involving special actions that are outside the ordinary course of business for your corporation or concern any shareholder contributions or distributions. So, for example, if your corporation is deciding whether to enter a major contract, or is deciding to merge with another company, or deciding to sell all of its assets, these types of decisions should all be recorded in minutes. Similarly, if your corporation decides to pay shareholders distributions, or it wants additional capital contributions from the shareholders, these types of actions and decisions should also be recorded in minutes or consents. If you don't keep records of these types of actions, you run the risk of having the decisions challenged as illegitimate by shareholders or third parties, or as being used to show that your corporation is not a real entity separate from you. Don't ignore your corporation's minutes. One of the biggest problems I see in most small corporations is that they fail to keep any minutes at all. And aside from the risk of piercing the corporate veil, the lack of minutes can cause all sorts of complications when it comes time to sell the business. I recently had a client who had difficulty in selling a business because he was unable to provide minutes showing that the corporation was properly transferred to him by his father. We eventually were able to fix the problem, but it caused all sorts of delays and additional expenses. The fourth important pillar of your corporate governance program is to have policies regarding fiduciary duties and conflicts of interest. Usually these policies are contained in the bylaws, but they can also be contained in formal written policies elsewhere. It is essential that all officers, directors, and shareholders understand these policies to avoid breaching them. In Massachusetts, directors and officers of a Massachusetts corporation owe two primary duties to the company: the duty of care and the duty of loyalty. The duty of care means that a director's or officer's actions and decisions must be made in good faith, with the care that an ordinarily prudent person would use in a similar position, and in a manner reasonably believed to be in the best interest of the corporation. So if you're trying to decide whether a corporation should sign a contract, you're required to make a good faith effort to do what's in the best interest of the corporation and gather whatever information a reasonably prudent person would gather in similar circumstances. So you may need to look at the numbers, review the contract, talk to your accountant or attorney if needed, and consider all other relevant factors in connection with the contract. You can't just sign a $200,000 equipment lease because you like the font that was used in the contract and claim that you're acting in the company's best interest if it all goes wrong. Massachusetts corporate law expects you to act the way a reasonably prudent person would act in your situation. If the officer or director does not meet the standard, he or she can be held personally liable and the corporation will likely be sued. The most important thing about the duty of care is that any officer or director has a defense for any potential violation of the duty so long as he or she complies with the standard set forth in the Massachusetts Business Corporation Statute. This means their action must be done in good faith, with the care that an ordinarily prudent person would use, and she must reasonably believe that her actions are in the best interest of the corporation. So long as these criteria are met, the individual will be exonerated and not be found liable. So, it's important that your policy or the duties for each officer and director identifies all the statutory requirements for the duty of care so that all of your corporation's officers and directors understand this duty and what they need to do to comply with it. That way, if the action turns out to be wrong, they will not be held personally liable. The second duty owed by officers and directors of the corporation is the duty of loyalty. The duty of loyalty means that the officer or director must put the corporation's financial interests ahead of his or her own personal financial interests. Two of the most common areas where potential violations of this duty occur in the following situations. First, when an officer or director or their affiliates enters into a transaction with the corporation, which is known as self-dealing. So, for example, if a director owns the building that the corporation has a lease with, this transaction implicates the duty of loyalty because the director has a financial interest in the transaction. Second, the duty of loyalty is also implicated when an officer or director or their affiliates seeks to profit by exploiting business opportunities in which the corporation might be interested in, or the person is operating a competing company. For example, say a client approaches your corporation about a new contract, but instead of bringing it to the board, you steer it to a separate LLC you just formed. That's a direct breach of your duty of loyalty, and the corporation or shareholder can sue you personally for it. To protect your corporation and your officers and directors from potential breaches of the duty of loyalty, you need to adopt a formal conflict of interest policy for your company. Your conflict of interest policy needs to answer 4 questions clearly. First, who's required to make conflict of interest disclosures? And ordinarily, this answer should be all officers, directors, employees, and possibly shareholders for a closed corporation, which we'll talk about in a moment. Second, the policy should identify and describe what counts as a conflict of interest, such as financial interests, family relationships, ownership stakes in other companies, corporate opportunities, and any other similar matter. Third, the policy should specify that any disclosure should be made in writing to the board of directors before the relevant transaction or corporate opportunity occurs. Fourth, the policy should also describe the procedure for how conflicted transactions are approved. Ideally, any potential conflict of interest transaction that is disclosed to the board of directors should be approved by disinterested members of the board or shareholders. But if there's no disinterested party, which often happens in small corporations, it must be proven that the transaction is fair to the corporation. This conflict of interest policy will also require that all officers and directors disclose any personal financial interest in a contract or a transaction that the corporation is considering, such as if the corporation wants to lease a building owned by a director before the transaction occurs. That way, the disinterested directors or shareholders can then review and approve the transaction before it's signed by the company. This will protect your company from the contract being voided and will also protect the director or officer from being held personally liable. With respect to potential corporate opportunities or operating a competing company, the conflict of interest policy should also require that the director or officer disclose any corporate opportunity or competing company that the person is involved in or becomes aware of. The policy should prohibit the director or officer from pursuing any opportunity or working for a competing company unless it's specifically approved by disinterested members of the board of directors. Seek help from a Massachusetts business attorney if you need help with the conflict of interest policy. They can be really tricky. Also, make sure to document every disclosure by an officer or director in the minutes for a meeting of the board of directors. That way, the corporation and the officer and director will have a legal safe harbor defense under Massachusetts corporate law in case you ever get sued over a matter involving a potential conflict of interest. Aside from officers and directors, another important thing to keep in mind is that under Massachusetts law, shareholders of a closed corporation, which represents the vast majority of small businesses in Massachusetts, owe each other a fiduciary duty of utmost good faith and loyalty. This is a very strict standard, and it's the exact same duty as the one owed by partners to each other in a partnership. So, in light of this strict duty, each shareholder of a closed corporation must be sure to disclose any potential conflict of interest in a transaction that the corporation is entering. This disclosure should be made to the other shareholders and to the directors of the corporation before the corporation enters the transaction. The fifth essential pillar of your corporate governance program deals with financial accountability and maintaining good standing with the state and your shareholders. A robust corporate governance program must include defined internal financial controls and a strict compliance calendar for when certain tasks should be completed. First, let's talk about state compliance. In Massachusetts, every domestic corporation must file an annual report with the Secretary of the Commonwealth of Massachusetts. This must be filed every year within 2.5 months after the close of the corporation's fiscal year. For companies on a standard calendar year, that means by March 15th. Failing to file this report doesn't just result in late fees. If it's neglected for too long, usually 2 to 3 years, the Secretary of the Commonwealth of Massachusetts will administratively dissolve your corporation. And if your corporation is administratively dissolved, the business effectively ceases to exist as a legal entity and should stop operating. If the business doesn't stop operating, the owners are potentially exposed to personal liability for any business activities to continue. Additionally, under the Massachusetts Business Corporation Statute, the corporation must also provide every shareholder, upon request, the company's annual financial statements, such as its balance sheet, income statement, shareholder equity report, along with an auditor's report or an officer's certificate. These financial statements, or a notice of their availability, must be given to each shareholder before the annual shareholder meeting or 120 days after the end of the corporation's fiscal year, whichever is earlier. Also, under the Massachusetts Corporation Statute, shareholders have a statutory right to inspect certain corporate records, such as accounting records, shareholder and director minutes, and various other items, provided the shareholder makes a written demand in good faith and for a proper purpose. A solid governance program will establish a clear internal process for how to handle these requests promptly and also make sure that shareholders get the required annual financial statements timely. With respect to financial accountability, there are a couple important things to do as part of your corporate governance program. First, you want to define exactly who can sign checks, open lines of credit, or bind the corporation to other significant financial obligations. Typically, the president and treasurer of a corporation are allowed to do these activities, but if you want to allow anyone else to do them, you need to specifically identify them with your bank and also in your own internal procedures. Also, depending on the size of your corporation and the number of stakeholders, you may also want to require that any contract over a certain dollar amount to be specifically approved by the board of directors via a formal corporate resolution. But that really depends on the size of your corporation and how many shareholders and directors are involved. If you only have one shareholder who owns all positions in your corporation, there really is no need to require director approval of a contract. Second, you also want to make sure to hire a bookkeeper either as a formal employee or as an independent contractor. Bookkeepers are essential for keeping track of all income coming in and all expenses going out of your business. Related to this, you also want to hire an accountant to help with your corporation's taxes. Third, you want to make sure to timely file all tax returns with the Massachusetts DOR and the IRS. Different types of businesses have different tax requirements, so make sure that you understand your corporation's tax obligations and keep up with them. Nothing can destroy a business more than unpaid taxes. Now, before I move on to the final, and perhaps the most important pillar for a multi-owner corporation, please take a brief moment to ensure that the information in this video reaches the local business community. If this breakdown of Massachusetts corporate law has been helpful, please click the subscribe button below and like the video. Subscribing ensures access to every upcoming episode of Small Business Legal Tips that keeps businesses safe, profitable, and legally compliant. Liking the episode really helps the channel and helps the YouTube algorithm provide these tips to other Massachusetts entrepreneurs who need to protect their hard work and their businesses. Thanks so much for supporting the channel. The sixth and final essential pillar of a corporate governance program is a comprehensive shareholder agreement, particularly one with buy-sell provisions. While the articles of organization and the bylaws are foundational documents for your corporation that every corporation must have, a shareholder agreement is a private contract among the owners. It's not required, but if there's more than one shareholder in a Massachusetts corporation, this document is absolutely vital. As we discussed above, Massachusetts courts hold shareholders in closed corporations to an incredibly high fiduciary duty of good faith and loyalty. This duty is very strict and often hampers the corporation and can lead to a lot of disputes and lawsuits among shareholders that allege shareholder freeze-outs or oppression or improper distributions. A well-drafted shareholder agreement mitigates these risks by establishing clear rules of engagement before disagreements arise and turns fiduciary duties into contractual duties that are easier to manage. Also, under Section 7.32 of the Massachusetts Business Corporation Statute, shareholder agreements in a closed corporation can also eliminate many of the other corporate requirements that are so onerous to comply with. For example, in a shareholder agreement, the shareholder can agree to any of the items listed on the screen. By agreeing to any of these items in a shareholder agreement, shareholders can make a corporation much easier and less burdensome to run. Additionally, here are some of the other important things that you'll want to include in a shareholder agreement. First, your shareholder agreement should have transfer restrictions to prevent the shares from being sold to an unwanted outsider. The agreement should state that if a shareholder wants to sell their shares, they have to offer them to the corporation or the other shareholders first, or that the corporation or the remaining shareholders have the right of first refusal if someone makes an offer to buy the shareholder's shares. Note that as we discussed earlier, you can also include these restrictions in the Articles of Organization or the bylaws, so a shareholder agreement is not the only place where they can be included. Any one of these locations is fine, but most corporations will want to include them somewhere. Also, if you include restrictions in multiple locations, make sure that they are consistent among all the different locations. Second, your shareholder agreement should also include provisions that require the shareholder to sell the shares back to the corporation or another shareholder under certain triggering events. As part of your shareholder agreement, for example, you should define what happens if a shareholder gets divorced, becomes disabled, leaves the company, files for personal bankruptcy, or passes away. Without provisions like this, a deceased partner's spouse or heirs could suddenly inherit the shares and become a new business partner overnight, which you may not want to happen. Third, your shareholder agreement should also determine exactly how your shares will be valued when a triggering event occurs. And there are lots of different options here. Will an independent appraiser be hired? Will a specific accounting formula be used? Will the shareholders get together each and every year and agree upon the value of the firm? And there are several other things you might be able to choose. However, agreeing on the formula ahead of time is essential and will save you tens of thousands of dollars in legal fees later. There are lots of other provisions that can be included in a strong shareholder agreement. Speak with a knowledgeable business attorney if you need assistance or have any questions. So there you have it. 6 essential pillars for your corporate compliance program. Customized articles of organization, bylaws, board and shareholder meeting minutes, clear fiduciary policies, internal financial controls and state compliance, and a comprehensive shareholder agreement. Together, these will make your corporation a real separate legal entity in the eyes of a Massachusetts court and will create a long-lasting, sustainable, valuable company. Without them, the protection you are hoping to gain by forming a corporation may not hold up when you actually need it. Here's what I want you to do this week. Take a look at your current corporate records. Ensure that your annual minutes are up to date and make sure that your annual report has been filed with the Secretary of the Commonwealth of Massachusetts. I hope you found this video helpful. If you found it helpful, please like the video and share it with another Massachusetts business owner who can use some help. Thank you so much for watching, and I'll see you in the next episode of Small Business Legal Tips.